Ma'am, stop what you're doing and come with us right now.
This is my home. I'd like to see the legal basis for this contact.
We're not here to argue. We need to see your documents.
I am Judge Renee Caldwell. You're making a mistake.
A woman is on her knees in her own front yard, planting flowers. Her own yard, her own flowers. A neighbor sees her, decides she does not belong there, and picks up the phone. Not to introduce himself, not to say hello. He calls ICE, on his neighbor, for gardening, and for a few hours it works. Federal agents show up. They put her in restraints. They take her away. The neighbor probably felt pretty good about himself that evening. But here is the part he did not see coming. If you are ready to see racial profiling blow up in someone's face in the most spectacular way possible, drop a comment below and tell me what state you're watching from. Seriously, take 5 seconds and do it now, because this community is growing fast and I do not want you to miss what is coming next week. Go ahead and hit the notification bell too, because next week we are covering a case that will make this one look like a parking ticket. And this one already has a federal judge in zip ties, so let that sink in. Now, let's talk about what actually happened here. The woman he called ICE on was the Honorable Renee Caldwell, a sitting federal immigration judge with nearly a quarter-century of experience. And 6 days after she was zip-tied in her own driveway, that same neighbor walked into a federal courtroom with his visa case on the line. She was behind the bench. He was at the respondent's table. And what happened next is something that no one in that courtroom or in that neighborhood will ever forget. Let's get into it. Renee Caldwell was 52 years old, and she was not the kind of woman you caught off guard. Not in a courtroom. Not in a meeting. Not in her own front yard. She had graduated from Howard University School of Law and spent the next 24 years building one of the most respected careers in immigration law in the entire state of Ohio. She started out as a public defender, fighting for people who had nobody else in their corner. Then she moved to the ACLU's Immigrants' Rights Project, where she supervised attorneys and took on cases that most people did not want to touch. And for the last 9 years, she had served as a federal immigration judge for the Southern District of Ohio, one of the most demanding positions in her field. In those 9 years, she had presided over more than 4,000 cases. 4,000. That is not a number you reach by cutting corners. The clerks in her courthouse had a nickname for her, the Velvet Gavel, soft in the way she spoke, immovable in every decision she made. She was known for being patient with people who showed up to court without a lawyer, for being precise in everything she did, and for having zero tolerance for anyone who tried to skip steps or bend rules. 2 different presidential administrations had tried to pressure her court into moving faster and doing less. She had outlasted both of them without changing a single thing about how she ran her courtroom. And in nearly a decade on the bench, not one of her rulings had ever been sent back on a constitutional error. Not one. This was the woman who, on a quiet Tuesday afternoon in late September, was on her knees in the front garden of her own home, pressing yellow chrysanthemums into the soil. They had been her father's favorite flower. He is gone now. And planting them was the closest she could get to him. What Marcus and Diane Holt did not know, and truly could not have known, was that Renee had just come back from burying her father. Gerald Caldwell was 79 years old. He had fought pneumonia for 6 weeks before it finally took him. 6 weeks of hospital visits, phone calls, and hoping. And then, just like that, he was gone. Renee had taken emergency leave from the court, packed a bag, and driven 4 hours alone to Cincinnati to handle everything. She planned the funeral. She wrote the eulogy and stood up in front of everyone and delivered it. Then she got back in her car and drove 4 hours home. Alone. The house was waiting for her when she got back. Quiet in that specific way a house gets when something is wrong. Too still. Too empty. The kind of quiet that sits on your chest. She could not work. She could not read case files. She could not sit at her desk and pretend that everything was normal, because nothing felt normal. So she went outside. She had bought a flat of yellow chrysanthemums from the nursery because that is what her father did every single fall. Every home he had ever lived in, every walkway he had ever owned, he lined with yellow chrysanthemums when the weather started to turn. It was just what he did. It was one of those small things about a person that you do not realize you are memorizing until they are gone. She was planting them for him. That was all. She was not Federal Judge Renee Caldwell that afternoon. She was not the Velvet Gavel. She was not a 24-year veteran of immigration law with 4,000 cases behind her. She was a 52-year-old woman in a straw hat and gardening gloves. 3 days out from her father's funeral, trying to find something to do with her hands, trying to stay present, trying to get through the afternoon. That is who Marcus Holt saw when he looked out his window and picked up the phone. She had been outside for about 40 minutes. That is it. That is the whole story of what she was doing. She had a trowel in her hand, a flat of chrysanthemums sitting in the grass beside her, and a bottle of water on the porch step for when she needed it. She was wearing a linen shirt, a pair of gardening gloves, and her father's old University of Cincinnati cap, the one he had worn so many times the brim had started to fade. At some point, the mail carrier came down the street. Renee looked up and gave a small wave. The mail carrier waved back and kept moving. Then Renee went back to what she was doing. She pressed her trowel into the soil. She made a small hole. She placed a plant. She moved to the next spot. That was the whole scene. A woman, a garden, a Tuesday afternoon. There was nothing unusual about any of it. There was no reason for anyone to look twice. There was certainly no reason for anyone to call a federal law enforcement agency. But Marcus Holt was watching from inside his house. He had moved into the neighborhood 8 months earlier. In 8 months, he had never walked across the street to introduce himself. He had never waved from the driveway. He had never knocked on the door. He did not know her name. He did not know what she did for a living. He did not know anything about her at all. What he did know, or thought he knew, was that a black woman doing physical outdoor work in front of a house this large did not add up in his mind. He did not ask himself why he thought that. He did not stop to question it. He did not walk over and simply say hello. He went inside. He found a number. And he made a call that he was absolutely certain, in that moment, was the right thing to do. He was wrong. He just did not know it yet. The 2 agents who responded to that call were Carl Pruitt and Dennis Vasquez, both deportation officers out of the Cincinnati ICE field office. Between the 2 of them, they had 19 years of enforcement experience. On paper, that sounds like a lot. But experience and judgment are not the same thing. And what these 2 had built over nearly 2 decades was not a track record of careful, responsible work. It was something else entirely. Their supervisor would later describe how their office handled tips like the one Marcus Holt made. He called it a low-threshold call response protocol. What that means in plain language is this. Someone calls in a tip, and the agents roll out. No independent check. No verification. No confirmation that the tip has any real basis before they show up at someone's door. Someone makes a call, and that is enough. Pruitt had 2 internal complaints already sitting in his file, both for using aggressive tactics during residential enforcement. Not one of those complaints had resulted in any serious discipline. Vasquez had a cleaner file on paper, but he had been verbally warned twice for the same problem, making contact with people without first asking for proper identification. Warned twice, nothing more. Here is what is important to understand about both of these men. In all their years on the job, not a single tip they acted on had ever come back to hurt them professionally. Not one. No complaint had cost them their badge. No mistake had followed them in any real way. They had worked long enough in a system that protected them to stop worrying about what happened to the people on the other side of those doors. They had learned, slowly, through years of zero consequences, that there was no reason to slow down, double-check, or ask twice. Nobody was going to hold them accountable. They believed that right up until the moment they pulled up to Renee Caldwell's house and stepped out of their vehicle. The black SUV rolled up to the curb and stopped. Pruitt got out first. His hand was already resting near his vest before his feet hit the pavement. He walked toward the yard and said, "Ma'am, we need you to stop what you're doing and come to the vehicle." Renee stopped. She looked up at him. Then she stood, slowly and deliberately, and she pulled off her gardening gloves 1 finger at a time. She was calm. Completely calm. "I'm Judge Renee Caldwell," she said. "I am a federal immigration judge for this district. This is my home. I would like to see the legal basis for this contact." Pruitt did not blink. "We're not here to argue. We need your documents." From just behind him, Vasquez said something. He said it loud enough that the Ring camera on the front door of the house next door picked it up clearly. 4 words. "They all say that," and he smiled when he said it. Renee did not raise her voice. She gave them her federal employee ID number. She gave them the direct phone number for her court. She gave them the name of her supervising chief judge and told them exactly how to reach that office. She told them, clearly and without any confusion, that continuing this contact without making any attempt to verify her identity would be a federal civil rights violation, and that she would personally make sure it was treated as one. Pruitt's response was to tell her she was impeding a lawful inquiry. Then the zip ties came out. They clicked into place behind her back. Renee did not pull away. She did not raise her voice. She did not cry. She stood completely straight, chin up, eyes forward. Her hands were bound behind her in her own driveway, 3 days after her father's funeral, standing in front of the yellow chrysanthemums she had planted for him that same afternoon. She said nothing else. What none of them had fully clocked yet was who was watching. The mail carrier had stopped at the corner and was standing completely still. The Ring camera on Renee's own front door was recording every second. Across the street, the Okafor family had gathered at their window, and their 17-year-old son Darius already had his phone up and pointed at the driveway, recording, before the SUV door had even finished closing. Everything was being captured. All of it. Let's stop right here for a second, because I want to make sure we are all clear on what had just happened. Agents Pruitt and Vasquez had a woman in zip ties in the back of their vehicle. No warrant, no verified tip, no probable cause, not a single box checked that the law requires before you restrain a human being and take them away from their own home. Nothing. They had a phone call from a neighbor who did not like what he saw when he looked out his window, and they had turned that into a federal detention. That woman was a sitting federal judge with 24 years of experience in the exact area of law these agents were supposed to be enforcing. She had given them her name, her employee ID number, her court's phone number, and the name of her direct supervisor. She had handed them every tool they needed to take 30 seconds and confirm who she was. They did not use any of it. So here is my question for you, and I genuinely want to know what you think. At the moment this was confirmed, the moment someone in that agency picked up the phone and realized what Pruitt and Vasquez had just done, should they have been fired on the spot? No conversation, no process, just done? Or should they have been given the option to resign first and walk away on their own terms? There is no wrong answer here. People land on both sides of this for real reasons, but I want to hear where you stand. Drop your answer in the comments right now. I read every single one, and this is exactly the kind of question where your perspective matters. Tell me what you think should have happened the moment that phone call went up the chain. When Renee arrived at the Cincinnati ICE processing facility, the person who handled her intake was Sergeant Phyllis Morton. 16 years on the job. She had seen a lot come through those doors. Morton was handed the paperwork. She looked down at the name on the form. Then she looked up at the woman standing in front of her. Something shifted in her face. She asked quietly, almost carefully, "Are you Judge Caldwell? Immigration Court, Lloyd D. George Division?" Renee said yes. Morton set the clipboard down on the desk. She did not pick it up again. She stepped away without saying anything else and made a phone call. That call went to her supervisor. Her supervisor made another call, this one to the field office director. The field office director went completely silent on the line for 4.5 minutes. Not speaking, not responding, just silent, in the way people go silent when they are trying to calculate exactly how bad something is. Then he called Washington, specifically the office of the chief immigration judge. After that, the chain went quiet. The kind of quiet that moves fast through a building without making any noise. People knew something had happened. Nobody was saying what. Then Sergeant Morton came back into the intake room. Her face was different now. The professional, seen-it-all expression she had walked out with was gone. What replaced it was something harder to name. Somewhere between serious and sorry. She stopped in front of Renee and said, "Judge Caldwell, I'm going to need you to come with me to a private office." Pruitt and Vasquez had been so certain they would never face real consequences that they had not even considered this moment was possible. It was becoming very possible, very fast. Renee Caldwell walked out of that facility at 6:47 in the evening. She had been held for 3 hours and 19 minutes. 3 hours and 19 minutes in a federal processing facility, in zip ties, in her father's gardening cap, while the chrysanthemums she had planted that afternoon sat in the soil of her front yard, still settling in. While she was inside that building, her mother had called. Renee had not been able to answer. Her mother, who had just lost her husband of 51 years and was still in the thick of her grief, had called her daughter and gotten nothing. That was the personal cost of 3 hours and 19 minutes. It was not a small one. When Renee walked out, she did not go home. She stood in the parking lot of that facility and she started making calls. The first was to her personal attorney. The second was to the National Legal Department of the ACLU. The third was to a journalist she trusted at the Cincinnati Enquirer, someone she knew would handle the story carefully and get it right. The fourth was to the Federal Law Enforcement Oversight Board. Then she requested documents. Not asked. Requested, in writing, on the spot. She wanted the names of both agents. She wanted the tip log showing the address the call had come from. She wanted every piece of intake paperwork with her name on it. And she got all of it. By 11 o'clock that night, the story had already appeared on 3 legal accountability blogs. The details were precise because Renee had made sure of it. By the following morning, 2 national outlets had picked it up and were running with it. Somewhere across town, agents Pruitt and Vasquez were ending their shift. They had not yet been told that any of this was happening. They had no idea that by morning, their names would already be in print. The call came in at 7:15 in the morning, 6 days after the incident in the driveway. It was Chief Immigration Judge Sandra Wellesley. She explained the situation carefully and professionally, the way you do when you are delivering information that you know is complicated. There was a removal case that had been moving through the docket for the past 4 months. The couple involved had overstayed a visa that was originally issued back in 2019. Their hearing was scheduled for the following Tuesday. The judge who had been assigned to the case had just gone on emergency medical leave. The case needed to be given to someone else, and it needed to happen quickly. Would Judge Caldwell be available to cover the docket that week? There was a pause on the line. Not a long pause, but a pause. Renee's hand tightened around the phone. She asked Judge Wellesley to do one thing before they went any further. She asked her to confirm the case number and read her the names of the respondents. Wellesley confirmed the case number. Then she read the names. Marcus and Diane Holt. The same address. The same people. The couple whose tip had put her in zip ties in her own driveway 6 days earlier, while she was planting flowers for her dead father, were now sitting on an open removal case, and their hearing was 6 days away. Renee did not react out loud. She told Judge Wellesley that she would need 24 hours to think through the recusal question carefully before giving her answer. She thanked her. She hung up. Then she sat with that information for a moment. The law was already turning over in her mind. She knew the standards. She knew the arguments, and she was already thinking about exactly how she would answer them. Here is where I need to stop and talk to you directly, because this is the part of the story where reasonable people genuinely disagree. Everything up to this point is pretty clear-cut. A woman was wrongfully detained in her own yard. The agents who did it acted without verification, without cause, and without consequence. Until now. The neighbor who made the call did so based on nothing more than what she looked like. All of that is straightforward. But this next part is not. Judge Caldwell had every legal right to take that case. Nothing in the law prevented her from sitting on that bench and presiding over the Holt's removal hearing. She had not made any rulings against them before. She had no prior professional history with them. Legally speaking, she was a completely valid choice. But legal and right are not always the same word. Some legal scholars who followed this case argued that she should have stepped back anyway. That even if the law allowed it, the appearance of a conflict was too strong. That justice does not just need to happen. It needs to look like it is happening fairly, from every angle, to every person in the room. Other scholars pushed back hard on that. They argued that removing a judge simply because the respondents were uncomfortable with who she was would set a dangerous example, that it would effectively let people use bad behavior as a way to pick their own judge. Both sides have a real point, and when this case went public, that debate spread fast. So I want to know where you land. Should Judge Caldwell have taken the case? Yes or no? And more importantly, tell me why. Drop your answer in the comments right now. I want to hear your reasoning. The Holt's attorney did not wait. The recusal motion was filed before 8 o'clock on Monday morning. It argued that Judge Caldwell could not fairly preside over this case because of what had happened between her and the Holts. It cited the appearance of bias and pointed to Canon 2 of the Code of Conduct for United States Judges, which deals with a judge's duty to make sure their impartiality cannot reasonably be questioned. It was a serious argument, and Renee had already seen it coming before the filing even landed on her desk. Her written response was 11 pages long, 11 pages, carefully and precisely constructed, that took apart every argument in the motion one at a time. She cited a Supreme Court case called Liteki v. United States, which deals specifically with when a judge's personal knowledge or experience can actually justify removal from a case, and when it cannot. She applied what is known as the extrajudicial source doctrine, which draws a clear line between a judge having a private personal grudge against someone and a judge simply having knowledge of facts that exist in the public record. The tip call Marcus Holt made to ICE was documented. It was not a secret. It was not a private matter between neighbors. It was a recorded act with a paper trail, and that made it fundamentally different from personal bias. She also pointed out something that was difficult to argue with. She had made 0 rulings against the Holts before any of this happened. There was no history, no pattern, nothing to point to. Her final line in the denial was the one that got quoted everywhere once the case went public. She wrote, "A court that removes its judges whenever a respondent finds their presence inconvenient does not protect due process. It eviscerates it." The motion was denied. The hearing would go forward. And on Tuesday morning, Judge Renee Caldwell would take the bench. Tuesday morning, Courtroom 4B, 9 a.m. The judge's door opened, and Renee Caldwell walked in. She moved to the bench the same way she always did. Steady, unhurried, like someone who had done this thousands of times, because she had. She set down her water glass. She positioned her legal pad. She placed her reading glasses where she could reach them. The courtroom settled into the kind of quiet that courtrooms are trained to produce the moment a judge enters the room. Then she looked up. Marcus Holt was sitting at the respondent's table, and she watched it happen on his face in real time, like weather moving across open sky. First there was confusion, the ordinary confusion of a person trying to place someone familiar in an unfamiliar setting. Then came recognition, and then came something that arrived after the recognition, something that drained the color out of him so completely and so fast that the word pale does not really cover it. Diane Holt reached over and grabbed her husband's arm. Their attorney leaned in close and said something quietly into Marcus Holt's ear. Marcus leaned back and said something in return. The attorney's expression did not change at all, because people who go to law school spend years learning how to keep their face exactly still in moments like this one. But his pen, which had been moving across his notepad, stopped. He did not pick it up again. The courtroom deputy would later tell a reporter that the silence in that room was so complete you could have heard a staple drop from across the hall. Judge Caldwell looked out at the room. Her voice was the same voice it always was. Measured, clear, entirely in control. "Good morning. We are here in the matter of removal proceedings against Marcus and Diane Holt. Counsel, are the parties ready to proceed?" She did not smile. She did not frown. She did not give them anything except the law. That was more than enough. The proceedings ran for 4 days, and the evidence that came out during those 4 days did not arrive all at once, in a single dramatic moment. It was built, slowly, steadily, one piece at a time, each one landing a little harder than the one before it. On the first day, the Ring camera footage was entered into the record. This was the footage from the camera mounted on Renee's own front door, time-stamped down to the second. It showed her in her gardening clothes, on her knees in the soil, trowel in hand, planting flowers. It showed her waving at the mail carrier. It showed her doing nothing, absolutely nothing, that could be interpreted as suspicious by any reasonable person. And then it showed the black SUV rolling up to the curb. The footage did not lie, and it did not exaggerate. It simply showed exactly what had happened, in order, from beginning to end. On the second day, the tip call log came in through the parallel civil rights proceeding that was running alongside the removal case. The log showed Marcus Holt's address. It showed the exact time he made the call, and it showed the language he had used when he made it. One phrase in particular entered the record and did not leave it. He had told the ICE tip line that the woman in the yard doesn't look like she lives here. 7 words. That was the entire basis for everything that followed. On the third day, records obtained through a Freedom of Information Act request revealed something that reframed the entire story. Agent Pruitt had initiated enforcement contact based on tips from that same zip code 23 times over the previous 18 months. 21 of those 23 tips involved Black or Latino individuals. Not one of the 23 had resulted in a confirmed immigration violation. Not one. On the fourth day, internal agency communications were entered, showing that both Pruitt and Vasquez had been informally told, 3 months before the incident, that their process for verifying tips before making contact was not good enough. They had been advised to fix it. They had continued doing exactly what they had always done. Each piece of evidence built on the last. By the end of the fourth day, there was not much left to argue about. And then Marcus Holt opened his mouth and handed the case to the other side. It happened on day 3 of the civil rights deposition running alongside the main proceedings. He was under oath. The question put to him was simple and direct. Not a trick, not a trap. Just a straightforward question that anyone paying attention knew was coming. Why had he called ICE instead of simply walking across the street, knocking on the door, and introducing himself to his neighbor? It was a question he should have been prepared for. It was a question his attorney had almost certainly walked him through. And yet what came out of his mouth in that moment was not a prepared answer. It was the truth. The kind of truth that comes out when a person has been holding it for too long and suddenly cannot find the shape of the lie fast enough. I am reading directly from the certified court transcript. He said, I didn't think someone like that would own a house like that on that street. I don't know how else to say it. I just didn't think it was right. His attorney moved immediately to redirect the questioning. Fast, professionally. Well, the way attorneys move when they recognize that something has just gone badly wrong, and the only option left is damage control. It was too late. The court reporter's fingers had not stopped moving for a single second. Every word was already in the record, sealed and official, before the redirect request was even finished. There was no walking it back. There was no clarification that was going to soften what he had just said under oath, on the record, in plain language. 11 seconds. That is roughly how long it took him to say those 3 sentences. 11 seconds of unplanned honesty, and the substantive legal debate in the civil matter was effectively finished before a single jury member had been asked to deliberate. Some cases are decided by brilliant legal strategies. This one was decided by a man who simply told the truth about what he believed. Let's sit with that for a moment, because what just happened in that deposition room is the kind of thing that law professors are going to be using as an example for a long time. Marcus Holt was under oath. He had an attorney sitting right next to him. He had been through the preparation process that every deposition witness goes through, where your lawyer walks you through the likely questions and helps you understand how to answer carefully and within your rights. He knew, or should have known, that he did not have to answer every question the way it was asked. He had options. One of those options was the Fifth Amendment, the right to not answer a question if the answer could be used against you. It is a constitutional right. It exists precisely for moments like that one. Taking the Fifth is not an admission of guilt. It is not illegal. It is not even unusual in a civil deposition. His attorney could have advised it. He could have invoked it himself. He did not. He answered the question, and the answer he gave was the realest thing said by anyone in that entire proceeding. So here is what I want to know from you. Should Marcus Holt have taken the Fifth instead of answering that question? Was his attorney asleep at the wheel? Or did Holt just go off script before anyone could stop him? And here is the deeper question underneath all of that. What do you think was actually going through his mind at that moment? Was it panic? Was it the strange relief that sometimes comes when a person finally stops pretending? Was he just not smart enough to stay quiet? Drop your answer in the comments. I genuinely want to know what you think happened in that room. The civil rights jury went into deliberation and stayed there for 7 hours. 7 hours is not a short deliberation, and it is not an unusually long one. It is the kind of time that tells you the jury took the work seriously, that they went through the evidence carefully, that they talked it through. And when they came back out and the 4-person stood up to read the verdict, the courtroom was so quiet that people sitting in the gallery later told reporters they could hear the ventilation system running in the ceiling above them. The verdict came in 2 parts. First, $180,000 in compensatory damages against Marcus and Diane Holt. This was the portion tied directly to their role in making the call that started everything. The tip that put a federal judge in zip ties in her own driveway with zero legal basis. Second, $620,000 in punitive damages against the Department of Homeland Security for the conduct of Agents Pruitt and Vasquez. Punitive damages are not meant to cover a specific loss. They are meant to send a message. They are the jury saying clearly and on the record that what happened was not just a mistake. It was the kind of behavior that needs to cost enough to make people stop doing it. Total, $800,000. Marcus Holt put his face in his hands. Diane Holt sat completely still, staring at the surface of the table in front of her, not blinking. Their attorney placed one hand flat on the table for just a moment, then lifted it and said nothing. Renee Caldwell was not in the room when the verdict was read. She was one floor away, presiding over a separate proceeding in her own courtroom. Her clerk came in quietly and passed her a note. She read it. She nodded once. She set the note aside and went back to her work. That single nod was the most Renee Caldwell ever said publicly about the verdict. The monetary verdict was significant. But what Judge Caldwell did next is what immigration law scholars are still talking about. In the removal proceeding, alongside the judgment, she issued what is called a structural order, a set of binding requirements aimed not just at punishing what had already happened, but at changing how things would work going forward. It was the kind of order that goes beyond one case and tries to fix the system that allowed the case to happen in the first place. She ordered 5 things. First, mandatory third-party identity verification before any ICE residential enforcement contact. No exceptions for so-called urgent circumstances, unless a field supervisor had reviewed and signed off personally. The days of rolling up to someone's home on nothing but a phone call were over, at least in this district. Second, a full 90-day audit of every tip the Cincinnati field office had acted on over the previous 3 years, with a specific breakdown of the race and background of both the people making the calls and the people being reported. The pattern that had shown up in the evidence was going to be examined completely and officially. Third, mandatory bias response retraining for every officer in the field office who had previously received even an informal caution about their conduct. Not optional, not suggested, required. Fourth, a plain language Know Your Rights card explaining enforcement contact rights, to be posted publicly on the agency's regional website where anyone could find it and read it. Fifth, quarterly compliance reports submitted directly to the district court for the next 24 months, showing exactly how the tip verification process was being followed. Then she looked out at the courtroom. The room was still, and she said, "The Constitution is not a courtesy extended to people who look like they belong. It is the floor, for everyone, everywhere, in every yard." The gavel came down once, not twice. Once. Clean and final, the way she did everything. The following Monday, Renee Caldwell returned to her full docket. Same courtroom, same bench, same measured voice. She has not given a single media interview since the incident. Not one. No television appearances, no newspaper quotes, no statements beyond what was already in the official court record. Whatever she felt about all of it, she has kept entirely to herself. The weekend after the verdict, she went outside and planted the rest of her father's chrysanthemums. Agent Carl Pruitt was terminated from the agency 60 days after the verdict came in, with his appeal still pending at the time of this recording. Agent Dennis Vasquez did not wait for termination proceedings to run their course. He resigned before the process was completed and forfeited his pension in doing so. 19 years of service, and he walked away from the retirement he had spent 2 decades building rather than face what was coming. Marcus and Diane Holt's removal case was transferred to a different judge. The reason was straightforward. Renee Caldwell had become a material fact witness in the civil matter, which made it impossible for her to continue presiding over their case going forward. As of the time this video was recorded, their immigration status remains pending. The case is still open. Darius Okafor, the 17-year-old from across the street who had his phone up and recording before the SUV door even closed, was contacted by 4 law schools after the case went public. All 4 offered him campus visits. He is currently considering pre-law. On Renee Caldwell's street in Claremont County, the neighbor on her left side brought over a fruit basket the week after the verdict. They reportedly talked on the porch for a while. It was, by most accounts, the kind of ordinary neighborly moment that should have happened long before any of this did. The house on her right, the one the Holts had lived in for 8 months without ever introducing themselves, is currently listed for sale. Some things on that street changed. Some things just quietly disappeared. Renee Caldwell had every advantage this country can offer a person. A federal appointment, nearly 25 years of credentials, a bar number, a judicial robe. She knew the law the way most people know how to get home from work. Automatically, completely, without having to think about it. She could cite the case name, the statute, the exact constitutional clause, out loud, in real time, standing in her own driveway in gardening gloves. And she still ended up in zip ties in front of her father's flowers, 3 days after his funeral, because a neighbor looked out his window, saw a black woman in her own yard, and decided she did not belong there. That is the part that has to stay with you. Not just the verdict, not just the $800,000, not just the agents losing their jobs or the structural reforms or the 11-page legal denial that made national news. The part that has to stay with you is that none of those things should have needed to happen. None of it should have started. A woman was planting chrysanthemums. That is where this story begins. And if she had been anyone other than who she was, it might have ended very differently. But she walked back into that courtroom. She sat behind that bench, and with 11 pages of legal reasoning, 4 days of evidence, and 1 clean strike of a gavel, she showed exactly who they had arrested. If this story moved you, please subscribe right now. It costs you nothing, and it means everything for keeping this kind of content coming. Drop a comment and tell me what moment hit you the hardest. Was it the zip ties? Was it the deposition? Was it the chrysanthemums? I read every single comment and I want to know. And share this with someone who needs to hear it. Because this story is not really about one judge. It is about every Black professional, every Black homeowner, every Black person doing something completely ordinary on a Tuesday afternoon who does not have a federal appointment to fall back on. Most people do not. And that is exactly the point.